Welcome back to a new episode of Counsel Commentary. Today I have two guests in the episode, so unique experience here. It's Roger and Anna from J.R. Henson Law. Welcome to the show.
Thanks, JT. We appreciate it.
Yes, we look forward to this.
Awesome, guys. So give us who else? Anna, do you want to start first? Kind of give you a little background how you got involved in law, and then go from there.
Yeah. So this is actually a family practice. Roger's my dad, and so I got involved in law. It's kind of funny. You grow up in small town, and everybody says, "Oh, are you going to be an attorney when you grow up? Are you going to be a nurse?" Like my mom's a nurse, and no, 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 no. And this in college, I was like, you know what? Actually, maybe yeah. I think I will become an attorney. So it's cool being exposed to it my whole life and then ultimately deciding, I got a degree. My undergrad degrees are in philosophy and strategic communication. And law is really the perfect marriage of those two things of learning how to think clearly, articulate yourself well, and create cohesive and logical arguments, and then communicate that strategically. That's kind of the name of the game. So it was a really nice transition into the field. And then to have a mentor like dad really was the icing on top of the cake. That's kind of how I got into it. But yeah.
And to expand on that, my dad was also an attorney. So Anna is third generation, three generations of attorneys here in Shawnee, Oklahoma. And I had a similar experience. My dad, when I was born, he was the county attorney here. Now it's referred to as the district attorney. And I remember sitting around the breakfast table and the dinner table, hearing some of the stories, and particularly when he was county attorney, and then being able to see him in the courtroom later when I was in high school and all. And it was something that I saw a lot of value in because Dad was helping people.
Mhm.
And in many respects, helping them find a way to get to the next phase of their life and to have sustainability and satisfaction of where they are.
Mm-hmm.
And so I liked it. I went to law school. I had decided by the time I was 13, I was going to be an attorney. And then became one. And then, lo and behold, my daughter decides to become one.
The genes are strong.
Yeah, no, the whole generation. But it gives you like, because I grew up in a real estate family. My dad and I obviously pursued real estate as one of my ventures. And so when you grow up and you absorb it, I think you have a step ahead. And initially, and I might maybe agree with me on this, initially you're like, no, I want to do my own thing.
Yeah.
And kind of like, wait, this is actually a good pathway. And if you could bring value and it adds value and you're excited about it, I think it's a
Yeah.
great way to navigate your future growth. What kind of first drew you into estate planning and trust law? It's kind of one, I know you guys do real estate and business law, but like let's start with that to begin with.
Start with estate planning.
Yeah, or if whatever if you want
Yeah.
to do real estate, whatever kind of,
Yeah.
because I know you focus more on the real estate. Is that correct?
Yeah, well, honestly, we both do kind of all of it, which is that's one of my favorite things. You never know what's going to come in the door, and it forces you to stay current and engage in all sorts of different areas of law and be able to help people in a wide variety of situations. But related to estate planning and trusts, that one, actually tying together your last question and this one, in law school, trust and estates was one of my favorite classes. It was trust and estates and property. And every time I got to the end of the semester and I kind of went, oh no, this is definitely my favorite class this semester, I would just laugh because it would be the type of law that dad practices. And
Yeah.
so trust and estates was one of those. And I found, in how dad does trust and estates and how he's kind of mentored me as well as how we both think about it, it's just a privilege to have an insight into people's lives because estate planning, you get to know someone's family really intimately. You see, you learn their fears, you learn their concerns, you learn who they trust, who they don't, what they ultimately want. It's a very deep insight into the core of a person. And so it's really an honor when people trust you to be the one to handle their last affairs.
Yeah.
And especially in a small town. So you've got, I think, not only is it just a privilege to be able to help people be at peace with something that's inherently hard to be at peace with your own mortality, help them be at peace with that, and also give them some peace of mind. And it's interesting to figure out how to make people's very specific wishes happen to the best of your ability. I mean, what would you add to that?
Well, yes, my dad did a lot of probate and wrote many wills when he was practicing law, and that has continued to evolve. And what's been interesting about watching the law over the last 49 years is how it has evolved to meet the needs of the people. Before then, back when I first started, it was wills. That was the primary way of doing estate planning, was you do a will. Then came along, or just before that, was joint tenancy. One of the biggest problems that existed at the time when I graduated from law school in 1976 is that the estate taxes here in Oklahoma, they would tax, there was no marital deduction. And so when a spouse died, the other spouse had to pay estate taxes. That's not true today. In fact, in 2010, Oklahoma did away with estate taxes. But there have been things that have been passed by our legislature that have actually benefited people. The key question at the very beginning that I ask people when they come in for estate planning is, what do you want to accomplish? Because if we understand the goal, then we're able to use the law to craft a way to meet that goal at a reasonable expense, and where what is left for the children is greater than what it would be otherwise.
Yeah.
Yeah, no, it's estate planning is one of the most powerful tools, and it's also one of the biggest things people have the biggest stress about, because they're like, how is it going to transfer to my family for future generations? And so to that point, what would be the difference between a will and a trust? One should consider one over the other, because that's, I forgot the exact number, but the average American doesn't even have basic foundation for estate planning. So what would be the difference between those two if somebody's considering one of those options?
Well, if I may address that, and I'll just be frank with you, JT. I'm not a big proponent of trust, except when the situation allows for it or calls for it. And as far as a trust is concerned, and this is the basic difference, and from my experience, a trust is created and a trustee is named. Typically, it's the settlor, or the one who creates the trust, is also the trustee, and then they name somebody to succeed them upon their death. But that requires administration of the trust currently. The expense of setting up a trust can be as much as the cost of a probate, or a significant cost of doing a probate. Nobody oversees that trust. Whereas if you have a will and you have to probate the will, the court is there to oversee, to make sure that that the wishes of the one who made the will are followed. Cost of a probate, is, like I say, is significant. Cost of creating a trust is also significant. But what most people don't factor in on a trust is that when it's time to distribute the corpus, or the assets of the trust, that there is almost as much expense there as in the creation. And that is particularly merited where there is discord among the beneficiaries.
Can I jump in?
Sure.
Yeah, so I would say, and again, all of this with the caveat of in Oklahoma law, just need to put that in there, that the way I often describe it to clients, because a lot of people, you hear everywhere, oh, I need to trust, I need to trust, I need to trust, I need to avoid probate. There are other ways to avoid probate, like non-probate transfers and things of that sort. So usually when we have an opportunity to sit down with people and discuss their assets and what they want to do, you don't need to go through the expense of a trust, and it'll be more cost at the end. And you've got to make sure you're funding it correctly. A lot of people don't add everything into the trust anyway. So then or they don't add everything into the trust. So then you have to probate anyway to get it moved into the trust and then distribute everything. So it's just a matter of really, what are your goals? If you've got very specific goals, if you've got tax related goals, whatever it is, or if you have a very significant estate, then a trust might make sense. But it really just depends on your assets and your goals.
I will add that as far as the trust is concerned, and Anna is correct. If you're looking at federal estate taxes, it behooves a person to take a really good, strong look at the use of trust.
Mm-hmm.
Another time that a trust would be warranted is where there's a blended family,
Mm-hmm.
or there are children that they want to benefit more than they want others. But there's got to typically be or a special needs child.
Mm-hmm.
Whereas if special needs child were to inherit the assets, that might actually kick them off of the program that they're on,
Mm-hmm.
that the state provides for their need and care and maintenance. And you don't want to do that, simply because once they're off, it's real difficult to get back on again.
Yeah.
So there are circumstances that merit the use of a trust, but just a blanket, trust for everything, I disagree with that.
I like that. It gives a clarity behind that situation. And what life stages should people start thinking about estate planning?
I mean,
Well, from my experience, I think most people need to start contemplating it when they're in their 50s or early 60s. And particularly when they're looking at retirement or about to retire. One of the tragedies that I have seen have been people who have put it off too long.
mm-hmm.
And I remember in one particular situation, this lady was a school teacher. She had never been married, no children. She claimed she was dirt poor. And she came in to see my dad. He did a will for her. She didn't want anything else. She left it all to a nephew. He strongly suggested, I might add, that she name an alternate in case he died. And she was convinced that she would die first. Turns out he passed away first. Then she was not capable of changing her will. And it was real interesting because I probated her estate. I was the one that called the nephew's children. He had one a natural child and one adopted. And I got a very interesting reaction from both of them. And she probably would have rolled over in her grave had she known that it was going to go to the two of them.
And I would say also, in the times to consider estate plans are times when there's a large change in your life. If you'll say, I'll expand on that a little more, because if you acquire an asset, so if you are a young adult and you buy a house, it's worth considering transfer on death deed or a will, something of that sort. Once you start acquiring assets, it's time to start thinking about designated beneficiaries. Once you have kids, time to start thinking about that. But at each moment when you have these big life changes, are times to review it. So when you get married, time to review it if you've already got an estate plan. When you have kids, time to review it. When you retire, time to review it. I had someone whose will, their most current will was 1978, when their child was an infant, who is now grown with kids who are grown. So it is like that just wasn't relevant anymore. It wasn't accurate to what she wanted. So yeah, I would say just being mindful of when you've got these new exciting big life changes, to also consider, okay, I might need to look at, is my will still accurate?
Yeah, that makes sense.
Or more to as much to the point as what Anna has said. not only is it accurate, but does it meet my needs as my life has changed?
Yeah, exactly.
Because
Yeah,
life is dynamic. Pardon?
When you start getting real estate involved and assets, like to Anna's point, that becomes those little assets become worth a lot more as they get paid off over time. And then
Right.
next thing you know, you don't want the state to have it. You want the family ends up wanting to fighting over it. So what would be the biggest mistake people make when creating like their estate plan that you've seen?
Not funding their trust correctly, I would say.
That would be one of the biggest mistake. Biggest mistake, a mistake, I don't know if it's the biggest one, is not to adequately anticipate things that may occur in the future. I've had people come in and say, well, I want to leave it to my 3 kids. That's fine. What if one of them passes away?
Right.
You know, do you want it to go to the remaining 2, or do you want it to go to the children of the 3rd child? Or what if the 3rd child doesn't have children now and do have children later?
Right.
You know, it's those things. We don't like to think about the fact that an entire family can be wiped out in an event. But I can tell you, JT, of 2 events come to my mind immediately where an entire family was wiped out from automobile accidents on the interstate.
Yeah. And it is hard to think about, but they are important things. Making sure you understand your estate plan and how to use it, and making sure that you genuinely consider all of the options that need to be considered.
And that's probably the key thing, Anna, is let's look at what is available, how do these various items meet the goals and needs of our clients, because there is a tapestry there in the law then, and how do we do that at a reasonable expense now, so that our clients and their family will have a reasonable expense upon that ultimate event.
Yeah, I've interviewed a few attorneys and they've had scenarios like that, not specifically in your type of law, but just like injury attorneys where they have had to like sue somebody from where the entire family passed away. It's crazy. For trust administration, what specifically happens during a trust administration when somebody passes away in that scenario, basically?
In that scenario, typically, I will say every trust agreement that I've seen addresses when the primary beneficiary passes away. It will then say it will either go to the surviving spouse, or it will go to the named beneficiaries for either an immediate distribution or to be distributed at some future point or some future event.
Yeah, the trust document should outline all of those things. So really, you just follow the successor trustee just follows what the trust document outlines. So it's somewhat unique in the sense of that person who created the trust, it's specific to what they wanted to happen. But on the other hand, it's somewhat standard still that you have your successor, you distribute according to the terms of the trust, you dissolve the trust, that kind of those steps.
And it becomes very important here that the trust agreement state clearly what the intent of the settlor, the one who made the trust, what his or her desire is to occur and all. And if you get a good seasoned attorney that is a wordsmith, if you will, they're able to state things with greater clarity.
Yeah,
that makes sense. What would be the main responsibility for trustees, and what mistakes do they often make? So people kind of look out for that.
Oh, okay, several different. You can tell we have opinions.
This could be a long question, it sounds like.
No, my first thing is, and I can't stress this enough, keep a good and accurate accounting. Keep your receipts where money goes, where it came from. Make sure that is all crystal clear, and don't do what we call self-dealing. Don't give yourself money. Don't do any of that. Like, don't know. You're in a fiduciary capacity. You have certain responsibilities that you owe to the beneficiaries in that kind of situation. So it's really important that you're meticulous in your accounting if you've got trust funds, if there's like actual money in the trust.
I would second that, emphatically. The other thing that I find one of the could be a problem area is the naming of who the successor trustee is. It can be a child, but they need to understand with significant clarity what the parents are wanting to occur upon their death. And it's been real interesting. I find it very interesting. Mothers tend to know their children better than the dads. And it has been, it doesn't happen every time, but frequently, the parents are sitting here in our office, and the dad will say, well, I'd like to have Johnny do this. And I look at the mom, and she's looking at her husband like, do you think Johnny can really do this?
You learn a lot about the family.
and it's not necessarily spoken, but you can see from the body language, who they trust and who they don't trust. Sometimes they trust the eldest, sometimes they trust the youngest. Sometimes they will trust the one who has a college degree and is doing well in business. They'll trust another one that is more empathetic to them. I mean, it's just...
Sometimes a third party. Sometimes the best option is to not have a family member be the one in charge. And that's okay too. Be realistic with yourself about who is honestly the best option for the purposes of, if your family's going to fight. Parents usually know if the family's going to fight, and who is realistically the best option, as well as who would, correctly take note of everything and account properly and all of these things. So it's a big responsibility depending on the trust.
And in that line where we know that the parents have indicated to us that a certain child is really going to be litigious, let's say, then we're able to draft language into that trust agreement that reduces the risk of litigation.
Yeah.
I'm not going to say it will eliminate it, but it will certainly give pause to the person who wants to litigate.
And, sorry.
No, come on.
I was going to say, and tell your attorney if you're anticipating that. This is it's a safe space. We've heard just about everything. You're not going to surprise us. And it's going to stay between us. It's not something that will be told to the community, but we can only serve you as well as what we know. So tell your attorney if you sign something stupid. Tell your attorney if you don't trust someone. Just say it. Tell us.
And JT, that is something that is very difficult. And I'm going to speak generally here. It is very difficult for any individual to be honest with themselves.
Mm-hmm.
Yeah, I love that. I think you have a really good goal nugget there, is give the attorney as much information, because they could, you're giving them, it's not just a boilerplate or boiler template. It's could be like, okay, we're going to actually put this based on your current specific needs and potential future problems that arise. One question I'd ask: can a trustee be personally held liable for errors?
I would say yes. It depends, but here again, you can have language in that agreement that releases the trustee of any of those kind of negligent errors. Now, then, if he is do acts of commission or omission. In other words, if he decides I'm going to do this, period, or I'm just not going to do it. I don't care what mom and dad said. I'm just not going to do it. I'm going to do it this other way. Then yes, I think that there is, I think ultimately pierce that trust veil and have the trustee ultimately held liable. But that is, in most cases, I think, a pretty long stretch.
Yeah, unless you've breached your fiduciary duty say one of the beneficiaries starts looking at the accounting and they're like, look, you've been paying yourself this amount of money that's not granted under the trust agreement, whatever it is, then that's a different situation. But yeah, so
we might make a comment here about fiduciary duty, and to just put it simply, that is looking after somebody else for their benefit.
Yeah.
I think and I'm getting away from the legalese and all that.
Mm-hmm.
You know, if a trustee is thinking, well, am I going to breach my fiduciary duty? The question is my action not going to benefit the named beneficiary?
Mm-hmm.
No, I like that context. You guys give it really in depth there. This is actually kind of like a question to that point. What are some warning signs that a trust or estate planning may lead to disputes or challenges down the road?
If it's ambiguous, and you can have like 100-page trust, and if it's ambiguous, usually the long trusts are ambiguous because it's simply overkill. But if it's ambiguous, you're inviting different interpretations and inviting people to fight about what it means. So you've got to make sure, and that's one of the reasons, honestly, why online forums are so dangerous, because they are. And I say that as someone who is a tech native. I grew up doing Microsoft Word lessons in school. So, but they are so dangerous because it's just a form and you don't have someone with the knowledge of this is how the court might interpret it, or these are some ambiguities or whatever it is. And you just fill it in without having the adequate language and clarity and that sort of thing. But I would say ambiguity is a huge part that invites litigation, especially for a particularly argumentative family.
I would like to take a little sidetrack here, and that is when it comes to forms that people fill out, whether they get them online, whether they buy them or whatever. I'm thinking of a particular probate that I was involved in. The gentleman had left a will, and in the will, he had 4 children. He cut 2 of them out. Specifically said, I don't want these 2 to have anything. I leave it to these other 2. Very next paragraph, I leave everything to my descendants.
So contradicts.
And see, descendants, and that's an ambiguity right there. You've cut 2 of the 4 out. Now you're leaving everything to the descendants. A descendant goes beyond an heir. An heir is the next person in line, bloodline, typically. Descendant, we were giving notice to 6-month-old kids, great grandkids, because they are a descendant.
Right, and it was just because he had just filled in the form, and the form had descendants.
Yeah.
But anyway,
the other thing, and getting back to your question, JT, one of the ways, and this is just a practical way, we know that may be an issue, is when one of the beneficiaries come in and they make the comment, I understand Dad and Mom were in here and did a trust. I want a copy.
Yeah.
No. Yeah. Mom and Dad are our clients.
Yeah.
What they do stays here. Period. Yeah. In fact, we try to figure out ways to not even acknowledge that the parent was in here to do a trust or any other, legal services.
Yeah, that could be open up a can of worms, because the people get other attorneys, they're like, oh, what assets do they have? And if it's transparent, then you got you call the ambulance chaser attorneys that wanted to get some new clients, like, oh, they have how much real estate? Yeah, I'll take that on. What role does digital asset play now? Because we've been talking to kind of like some online forums. What role does digital asset planning now play in estate work? Is like you're seeing a lot of people, like some of your competitors, or the people using online forms, and what are some of the pitfalls and challenges from that? Besides what you mentioned, but
Yeah.
I think one of the pitfalls of using online forms is not understanding the legal concepts and theories behind them. This is not a business where you just fill in the form and think you've got it done.
yeah,
I don't know of any attorney anywhere that doesn't have a set of forms in a given area of his practice, his or her practice. The key to it, though, is that's the beginning point.
yeah.
There is no need to reinvent the wheel when the wheel's out there. The question is, do you expand the wheel or what? You know, you tailor it to the specific needs of the client. And that takes time.
And it could look like a totally new document. You could start with one, I don't know, some random quitclaim deed. And then by the end, it could look like essentially a different document because you've done so many different changes to make sure it fits what the client wants and that it actually can do what it's trying to do. And so when people try to do it themselves, you know, they'll leave off, say, keep the quitclaim deed example. You can get quitclaim deeds online easily. You can get them from county clerks, whatever. But if you write the legal description wrong, if you don't have it incorrectly, then you could be looking at a quiet title, which is thousands of dollars. You could be looking at an invalid conveyance because it wasn't as sufficiently particular. You know, so it's really a matter of knowing the theories behind it allows you to make sure that the documents are actually doing what you want them to do. So there's that element of the law and the digital age, I guess, is kind of the idea. But then so I have a few different thoughts with your question, but were you asking more about how is digital media and sort of things impacted the practice, or are you talking about digital assets? I got those mixed up.
Your first point to your
First
practice,
point.
because everything's going digital. So
Okay. Yeah. That was something in law school. I took like a legal entrepreneurship class, and we talked about a lot of different things and about different ways to meet client and consumer needs within the digital realm. You know, do you offer digital packages that you can download? Do you have, but the thing is that attorneys are held to a professional standard too.
Yeah.
So we open ourselves up to danger if we're just saying, oh yeah, download this digital package, it'll do what you want it to do. Because I can't guarantee that it will do what you want it to do if you don't fill it in correctly, but my name's on it. You know what I mean? So there's that element as well. And of course, we want our clients to get the best possible documents and the best possible results that we could achieve if we can. So it's kind of, I don't know of any attorneys in town that offer forms like that or digital sorts of things, just because everything is tailored to the situation. What do you think?
I agree.
Yeah.
So basically, yeah, get the lead in, and then you have to get them on the conference in person or on the phone to actually find out their exact needs.
Exactly.
Without being, because you're also a lawyer, you want to be in like a, you know, US is very litigious, so you don't say, hey, we'll solve this without actually finding out what their case is or potential opportunity.
Right. Yeah, we get calls all the time of people saying, well, what's a base estate plan cost? And it's like, I would love to talk to you about what you would even need. Yeah. It's like, what do you even need? Let's sit down and talk so I can tell you these tools will help accomplish your goal. And then we can talk about these tools typically cost this much, you know?
I want to take a little sidebar on this. When people call and say, how much do you charge for a given document, or what's your hourly rate? You know, I could tell you what my hourly rate is.
It's not going to solve their issue. Yeah.
No, it's not going to solve their issue.
And don't go to the doctor and ask them what their hourly rate is.
But the other thing, though, JT, is they can go to an attorney that charges, say, $200 an hour. And that attorney takes 10 hours to do the work. So that's $2,000. They could go to an attorney that charges $300 an hour. He sounds more expensive. Yes, by the hour he is, He gets it done in 3 hours.
Yeah.
Which one is the more expensive?
Hey, pay for value, not time. Yep.
Exactly.
It's just,
Yeah.
yeah. Anyway.
And what I have found is
I'm in business, so it's always about paying for value and expertise.
Yeah.
And time back. It's not about who's the cheapest, who give me the results and what
Yeah.
serves me best.
Right.
Without naming names, could you share a memorable case where proper planning made all the difference in the world?
Okay. Give me a second to think. Where proper planning made all the difference in the world.
Like estate planning or even business planning, if you want to use a business or real estate planning.
Well, there's one that actually it goes back many years ago. Dad had done his clients had come in, they owned like 1,500 acres of land. And they had decided that they were going to leave everything to their youngest daughter. They had become estranged from their son and eldest daughter. And they decided that they were going to leave, like say, everything to the youngest daughter and reserve to themselves the life estate. 15 years later, let's move the clock to present. The son comes in and he says, I'm entitled to that 1,500 acres. And I shook his head, said, no, I don't think so. He said, my parents had no business and were not in their right mind leaving it to my youngest sister, period. And I posed the question to him, what were your parents like 15 years earlier? Did they know what they were doing? Oh, Dad knew exactly what he was doing. He was good. He knew how to farm. He could get the best out of the land. Mom was great, da, 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 da. They knew exactly what they were doing. And I said, sir, here's the document. If you'll notice the date was 15 years ago. You just told me they knew exactly what they were doing. Here's where they left it to your younger sister. You're out of luck. He left. He was not another word was said. But the parents' wishes were properly followed. The youngest daughter got the land. But she also had taken care of them for 15 years.
Yeah. No, this is a perfect segue. So how can people make conversations about estate planning less awkward with family members? So like situations like this don't even happen, basically.
Every family is so different. Every family structure is different. Every family is dysfunctional in its own way. The longer I'm in this business, the more I will stand on that. Everybody has their things. So It's hard to say that there's like a one size fits all for what makes things awkward versus not. But I think ultimately it will never get better if you don't talk about it. So you don't have to talk about it all at once, even just, approaching that topic, kind of sussing it out, seeing how your family interacts with it. And then you can come back to it at a later date, whatever it is. I would just say, don't make assumptions about family and how it's going to go or anything. And if you want to talk about it with your family, your family's not entitled to know it either. So if it's something you don't want to talk about, you don't have to. But if you want to, it will never get less awkward if you don't just start the conversation. Does that kind of...
It's families always have the biggest, when money becomes involved, things change. They're friendly. So
when Mama and Papa die, true colors are shown. And what's interesting there, and I'm going to delve off into a situation where I've had clients in that do not want to tell their children what's going on.
Yeah.
And that creates discord among the kids upon the death of both parents. And what's worse is I can think of 2 or 3 over the many years where one parent has told one child one thing and told another child another thing and told the third child of something else.
Another thing.
Yeah.
That's their favorite child.
and I see that they are having a very difficult time reconciling it.
Yeah.
Among the three upon the death of the parent. In fact, I don't think it gets reconciled at times.
Yeah.
Yeah, that's the biggest issue. Like I think with the estate planning is just figuring out everything is divided and keeping emotions at bay and people like knowing what they're gonna get ahead of time so issues like this don't evolve. If somebody's listening, and when I was talking with Sal from Top Attorneys of North America, and I think this is a great conversation. Because in law school, both of you guys, as you know, they don't really talk about how to grow your practice. What are some like tips if like some lawyers listening to this, if there's lawyers listening to this, what would be some like tips they need to do like to grow their practice, how to get clients, and like how do you grow your business?
I would say, and I'm going to go back to, I will tell you how my dad did it back in 1948, and that is he became involved in local politics, ran for county attorney, was successful in the election, and after 2 years, his name was well known throughout Pottawatomie County. And then after that, he became involved in a local civic organization. It was the Kiwanis Club of Shawnee. When I came in, I think one of the key things is getting your name out and let people know that you are practicing law, that one is practicing. And what I did, I became active in the community theater. Now then, the one who encouraged me happened to be my debate coach from middle school. She said, I want you to come out here, you need to get involved. One would not think being involved in a community theater would be beneficial practicing to the practice of law. But what was helpful is knowing and being able to read your audience. Who do you quote play to? Who do you look at? How do you present yourself? What's the lighting like? All that sort of stuff. I mean, oh my goodness, I just had several stories come to the back of my mind, but we won't delve off into that. But the other thing is being active in a civic organization. And when I say active, don't be just a member. Jump in with your feet, get wet. If they're like here at the Shawnee Kiwanis Club looks after youth. We do like Little Olympics. We've done it now for 93 years running. We help kids at Christmas. We give scholarships. I mean, we're working with other leaders in the community, and that's where business comes from.
Yeah, I think involvement in the community, even if you don't choose to do a civic organization, though that is incredibly helpful because you make a lot of connections every week. But finding some way to be plugged into your community, whether that's through a civic organization, through a book club, through a church, through some other type of volunteering effort, just being involved with the people around you and finding ways to engage in the community is, I would say, the most critical piece.
And don't be afraid when they start asking questions to give them a straight answer. I mean, it's not uncommon for people to ask me about a question or something about, well, how, I've got some property out here. How would be the best way to get that to my kids?
Mm-hmm.
And so, I don't charge for that. I just tell them this is what you need to do. I'll tell you what, Roger, we'll come in. Let's just make an appointment. We'll come in and we can discuss this further. Hey, that's great.
Yeah.
And they do. And we do.
Yeah.
No, I love that. I sat on different charity boards in Chicago for years, homeless dogs, battered women, abused children, and then also kids trying to get scholarships to go to culinary. So I've did to help with different organizations with their marketing and exposure. So yeah, I totally agree with that. It's a great way to get trust, but also you're giving back at the same time. You're building relationships. You're out in the community. People see you as somebody that gives back, helps, and is evolved, and helping the community. It comes back to you in different ways. Maybe not immediately, but like And also you're helping people. That's all it comes down to.
Absolutely.
Well, JT, that's the paradox of it, is by helping other people, one's business will grow.
Yeah.
And this is fundamentally a service profession, you know?
Yeah, serving others first. Yeah.
Absolutely.
Add value first, take care of other people first, and with no expectation, and then it comes back to you. The right people align with you. So
Yes.
100% agree with that. As we wrap this up, you guys have been amazing. What would be the best way for people to find more about you, like your website or email or any information you want to provide?
Yeah, we do have a website, J. Roger Henson PLLC. If you just search that in Shawnee, Oklahoma, the website will come on up, and then you'll be able to find our contact information on there. And I would say that's probably the best way for people to reach us is find the website, give us a call.
Right.
What's your number? You want to put the number in? You can plug it in.
405-273-8558.
Perfect. Thank you guys so much for being on Counsel Commentary.
Thanks, JT.
Thank you.
Appreciate it.
Appreciate you.
Thank you for listening to Counsel and Commentary. This episode has been brought to you by the top attorneys of North America.